Move now to consideration of H 1940, an act to adopt the Uniform Family Law Arbitration Act. Welcome a panel for 5 minutes of Carrie Behrman from the Uniform Law Commission and Maureen McBrien, Rick Jones, McBrien, and Hickey.
Good afternoon. My name is Maureen McBrien. Thank you, Chairs Day and Edwards, and to members of the Judiciary Committee for the opportunity to speak today on House Bill 1940, an act to adopt the Uniform Family Law Arbitration Act. And thank you to Representatives Ramos and Cataldo for sponsoring the bill. I'm a divorce and family law practitioner for 20 years at Rick Jones, McBrien, and Hickey in Needham, Massachusetts. I'm asking that you vote this bill favorably out of committee so that Massachusetts can be on track to follow suit with 8 other states that have already adopted the act to afford residents and your constituents another path to resolve their divorces and other family law disputes. Massachusetts does have a Uniform Arbitration Act, but that's a commercial arbitration statute at General Laws Chapter 251. And as you can imagine, that does not apply well to family law matters. Further, current case law discourages the use of arbitration in family law because the cases treat it analogously to special master proceedings, which are not binding but result in recommendations rather than determinations. The proposed act would reconcile with and customize arbitration practice to the unique context of family law practice. Its enactment would ensure predictability and consistency. The Uniform Arbitration Act seeks to maximize self-determination of individuals and couples in family law matters by permitting them as a matter of right to submit matters to binding arbitration by agreement only, but subject to the court's continuing parens patriae obligations for best interests oversight of child-related matters such as parenting, custody, and child support. The act would impose no new burdens on the courts and would result in some lightening of the enormous and taxing caseload that our probate and family court judges experience. Currently, it can take years to wind through the system to obtain a divorce, during which time families are unable to move on and circumstances change. Sometimes you'll get a judgment, and by the time you get a judgment, the family circumstances have changed such that further litigation is warranted. When particularized to the practice and with the ability to select an arbitrator, timing, rules, processes, locations, budget, and privacy, arbitration will provide and regulate one more voluntary outlet for would-be litigants without taxing or undermining any institution or individual. This would offer families a quick and more cost-effective and flexible alternative to traditional family law litigation, and it would empower families to resolve disputes with great efficiency and privacy. I'm asking that you vote this bill favorably out of committee, and now I would like to pass it along to Carrie Behrman of the Uniform Law Commission.
Thank you so much, Chair Edwards, Chair Day, and members of the Joint Judiciary Committee. I'm Carrie Behrman. I'm Legislative Counsel at the Uniform Law Commission. I've submitted some written testimony as well, but wanted to highlight just a little bit about the ULC. So the Uniform Law Commission is a state-supported organization that was established in 1892. We are made up entirely of volunteer attorneys who aim to provide states with nonpartisan, well-conceived, and well-drafted legislation that aims to bring clarity and stability to areas of state law. So as Maureen mentioned, the Uniform Family Law Arbitration Act was finalized by the Uniform Law Commission in 2016. Since then, 8 other jurisdictions have enacted the act, and we're hoping for a few more this session. And probably the most frequently asked question that comes up with this act is, what are some of the reasons why someone would want to go to arbitrate their dispute instead of go through litigation? And that really is the Act's ability to allow parties to tailor the process to fit the unique needs of their family law matters and dispute, such as setting deadlines that coincide with parties' schedules, or establishing a discovery schedule focused on the prompt and early exchange of necessary information, selecting an arbitrator with specialized knowledge and expertise to handle issues that might be unique to that particular dispute, and obtaining the arbitrator's award within 30 days of the hearing. With that, I will be happy to answer any questions the committee may have.
Thank you, Ms. Bierman. Any questions from the committee at this time?
Mr. Chairman.
Yes,
Thank you. Just want to thank both of you and especially Maureen for bringing the bill to my attention and for explaining it to the committee far better than I could have, although I can't say the same about my colleague, Rep. Ramos, who's an expert on these matters. So thank you so much.
Thank you both for your testimony.
Thank you.